We begin tonight with breaking news. We have obtained what is expected to be a central piece of the government's case against Donald Trump. The actual audio recording of the former president talking as if he's showing a highly classified document on U.S. war plans against Iran with people not clear to even know it exists, let alone what's in it. In a moment, only on CNN, you will hear what jurors will hear one day. The recording was made 2 summers ago, July 2021, at the former president's club in Bedminster, New Jersey. You will clearly hear the former president as he is speaking to several people. According to the special counsel's indictment, they include a writer working on Mark Meadows' memoir, the publisher, and 2 of Trump's staff members. The president was aware he was being recorded.
So picture yourself inside a federal courtroom as special counsel. Jack Smith steps forward to present what most observers expect to be another routine moment in the classified documents case. Involving Trump, the expectation is familiar. Prosecutors make their arguments, defense lawyers raise objections, and the judge manages procedural matters. Nothing appears unusual. Then the atmosphere changes. Smith introduces an audio recording from a 2021 meeting at Trump's Bedminster Golf Club. As the recording plays, Trump can be heard discussing classified material related to U.S. military plans concerning Iran with individuals who clearly have no security clearance. These are not government officials. They are private citizens. Then comes the statement that alters everything. Trump says plainly, "Now I can't declassify." That one sentence effectively collapses his entire defense. It undermines the claim that the documents were somehow declassified by mere intent or by being taken when he left office. According to reports, the courtroom falls quiet as the significance of that admission becomes clear. This is Trump, in his own voice, acknowledging the materials are still classified, while showing them to unauthorized people. This is not circumstantial proof or testimony that can be reframed. It is direct, decisive evidence. Trump's own words, recorded on tape, admitting to conduct he has denied for years. Reports also note the judge appearing visibly taken aback as the consequences settle in, while prosecutors work to maintain composure as this critical evidence is formally entered into the court record. This is the first time we are actually hearing this audio. We had previously seen a transcript. There seems to be more here than what was reflected in that written version. What stands out to you? Yes, there is clearly additional context. And this clip is only about 2 minutes from a recording we are told lasts over an hour. But this segment is central to Jack Smith's investigation. But hearing it makes the impact unmistakable and directly contradicts what Trump has been saying. Even just days ago, he claimed there was no specific document. Yet you can hear him clearly referring to something he is holding. Now, let's examine what this Bedminster audio actually demonstrates and why it is so damaging too. Trump's legal position in the classified documents case. This is not a rumor or a second-hand description that can be dismissed. This is the type of evidence that lands heavily in a courtroom. The kind that causes even the most committed supporters to pause and say nothing. The recording comes from a July 2021 meeting at Trump's New Jersey Golf Club, after he had left office. He is meeting with writers and others connected to a book project. These are civilians with no security clearances and no authorized access to national defense information. Yet on the recording, Trump appears to be showing off. He produces documents related to possible U.S. military action against Iran and discusses them as if they are achievements, outlining military planning and options that were considered. Then comes the statement that dismantles his public defense strategy. On the recording, Trump acknowledges that the documents remain classified, and that he no longer has the authority to declassify them because he is no longer president. The phrase, "now I can't declassify," is legally explosive. Why? Because it directly contradicts the narrative Trump and his allies have promoted for months, that he declassified everything automatically or mentally, simply by thinking about it or by removing documents from the White House. If that were accurate, this statement would make no sense. It exists only if he understood the documents were still classified and that he no longer had the power to change their status. And that distinction matters because this case is not just about possession. It is about knowledge and intent. When someone is recorded acknowledging that materials are classified, recognizing they lack authority to declassify them, still discussing them with people who have no clearance, this is not confusion. It reflects awareness. It reflects understanding. It reflects willfulness. This is also the type of evidence prosecutors hope for, because it is not a witness who can be attacked as biased. It is not a disputed interpretation. It is the defendant's own voice making the case. And this is where the political reality becomes unavoidable. Trump's team wants this case to feel abstract. They want it framed as procedural complexity, paperwork disputes, or institutional harassment. But audio like this cuts through that narrative. It makes the issue concrete. It makes it clear. It allows ordinary people to grasp what is happening without legal training. The Bedminster recording is only the opening development. Because what Jack Smith presents alongside it turns a single damaging episode into a much broader evidentiary case. Based on reporting and how prosecutors are presenting this in court, they also have testimony from Usil Taveras, the IT administrator at Mar-a-Lago, who reportedly began cooperating after initially providing statements that protected Trump. This is where the situation shifts from uncomfortable to legally serious. Taveras is not a peripheral figure. He is the individual with access to the security camera systems, the person who can explain what footage existed, what was requested, and what actions were taken. The allegation is significant. Prosecutors claim that after Trump's lawyers received a subpoena requiring preservation of evidence related to the storage and handling of classified documents, Taveras was instructed to delete relevant security camera footage. That is not a simple mistake or administrative oversight. That is classic obstruction. The purpose of a preservation subpoena is to prevent exactly that outcome. Do not destroy evidence. Preserve it. If the response is an attempt to delete footage that would show the movement of boxes containing classified materials, prosecutors do not need to exaggerate. The narrative is clear. And if the person who managed the system is now explaining who gave instructions and when, it becomes extremely difficult to argue that this was an innocent misunderstanding. Obstruction cases often hinge on timing. The closer the alleged deletion or concealment is to the legal demand to preserve evidence, the stronger the inference of intent becomes. There is also another layer that affects everything else Trump faces legally. Prosecutors have presented what has been described as a lawyer's admission. The suggestion that Trump's own attorney acknowledged manipulating or shaping the evidentiary environment in this case. Even without dramatic framing, the implication is severe. It points to a coordinated effort to hide, alter, or interfere with the evidentiary record. Once a court accepts that possibility, the damage extends beyond a single argument. It erodes credibility. It removes the assumption that the legal team is acting in good faith. Courts generally extend baseline trust to attorneys because they are officers of the court. But when evidence suggests a lawyer helped compromise the record, judges begin scrutinizing every filing and statement from that team. That is the difference between a difficult case and one that is nearly impossible to win. This is why the judge's response is so important. If the court establishes a presumption of bad faith, the entire balance shifts. Trump's legal team no longer benefits from default credibility. They must affirmatively prove they are not engaging in improper conduct, which is an extremely difficult position when a strategy has relied on delay, confrontation, and confusion. This leads directly to the crime-fraud exception. Attorney-client privilege is among the strongest protections in U.S. law, but it is not absolute. It does not apply when legal communications are used to advance a crime, such as obstruction or destruction of evidence. If the judge determines there is sufficient evidence to invoke the crime-fraud exception, prosecutors can gain access to communications between Trump and his lawyers that would otherwise remain protected. Not summaries, not partial excerpts, but complete communications, unredacted. The type of material that can establish direct involvement and intent. And consider what that does to Trump's overall defense strategy. For months, his approach has relied on distance. He has tried to shield himself behind attorneys. He has tried to point to staff. He has tried to suggest that he did not personally direct anything, that events were the result of confusion, that responsibility rested with others. Crime-fraud exception rulings remove that insulation. They give prosecutors a direct route to show who knew what, who gave instructions, and how internal decisions were discussed and justified. Now step back and look at how prosecutors are framing this as part of a broader pattern. They are not treating the Bedminster incident as an isolated mistake. They are not presenting the alleged deletions as a single unauthorized act. Instead, they are outlining a pattern of resistance. A legal and political posture in which legal obligations are treated as optional when they conflict with Trump's objectives. That is where references to more than 700 blocked executive orders become more than background detail. Whether the figure is used rhetorically or as part of a formal pattern, the message is consistent. Prosecutors want to demonstrate an ongoing approach to governance and compliance, one that views courts as barriers to overcome rather than limits to observe. Pattern evidence matters because it helps establish intent and the absence of accident. It separates, "I didn't realize from this is how I operate when I want something." Then come the contempt referrals. When a judge issues contempt referrals, it reflects a belief that court orders were deliberately violated or that the judicial process was intentionally obstructed. That is not routine criticism from the bench. It is escalation. It is the court signaling that the conduct may warrant prosecution and punishment. That is when the dynamic shifts. Trump has long operated in an environment where consequences are postponed, softened, or converted into political advantage. But contempt findings, privilege breaches, and the risk of enforcement actions are not messaging problems. They are real legal pressure. You cannot spin your way around court enforcement when a court is committed to enforcing its authority. Now connect that to the reemergence of the 37-count indictment. One crucial point here is that procedural dismissals are not exoneration. A dismissal based on procedure is not a finding that crimes did not occur. It addresses issues like appointment authority, jurisdiction, or technical process. If those issues are resolved or litigated again, prosecutors can revive the full range of charges, including willful retention of national defense information, conspiracy to obstruct false statements, and related counts. And they are not returning with the same evidentiary posture. They are coming back with additional cooperating witnesses, alleged orders to delete evidence, attorney admissions, potentially broader access to communications if privilege is pierced. That combination is what makes this so damaging. The legal significance of the Bedminster tape directly connects to what prosecutors must prove under espionage-related statutes. Particularly 18 U.S.C. Section 793, they must show the information involved national defense, that it was possessed without authorization, that the defendant understood what it was, and that the defendant willfully retained or disclosed it rather than returning it as required. Defense teams often focus on the knowledge element, arguing the client did not realize the material was classified, did not grasp its sensitivity, or misunderstood its status. The Bedminster recording undermines that argument entirely. Trump says it himself. He acknowledges the classification. He acknowledges he lacks authority. That is precisely what prosecutors need to establish knowledge. It also dismantles the declassification narrative. If Trump genuinely believed the Iran documents had already been declassified, he would not say, "Now I can't declassify." That statement only makes sense if he understood the documents were still classified. That is why prosecutors describe it as smoking gun evidence. Not because it is sensational, but because it satisfies multiple legal elements at once. It is an admission against interest. It combines awareness and conduct in a single recording. Then there is the obstruction theory. If Tavares testifies that deletion requests occurred after a subpoena demanded preservation, prosecutors can argue aggravated obstruction. The timing suggests conscious awareness and deliberate resistance to legal process. If the deletions were selective rather than routine system maintenance that further supports intent, the attorney admission element deepens the problem. It corrodes trust. If one lawyer acknowledges manipulating evidence, prosecutors gain justification to scrutinize other handling of evidence, demand forensic reviews, and question whether court filings were accurate. It also pressures the judge towards stronger oversight because the court can no longer rely on representations from a team viewed as acting in bad faith. That is why crime-fraud exception rulings are so consequential. They open access to communications prosecutors normally cannot reach. They can reveal planning conversations, instructions related to concealment, and strategies designed to avoid compliance. If those communications exist, the case becomes even more direct. Now consider the political timing. If Trump is attempting to govern during a second term while this evidence is being publicly examined, it becomes a constant drain on attention and legitimacy. Every day dominated by this case is a day policy is sidelined. Each discussion of the tape reminds the public of allegations involving national security. That carries downstream political effects. Prosecutors do not need electoral success. They need a conviction. But elected officials must face voters. If voters see a president entangled in allegations of classified document mishandling and obstruction, it creates a difficult environment for Republican candidates. Heading into 2026, political messaging becomes simple. You play the tape and ask a single question. Is this acceptable? The impeachment and removal discussion also becomes more concrete. If members of the House pursue impeachment, publicly introduced evidence matters. Audio played in court matters. Sworn testimony matters. Judicial findings of bad faith and obstruction matter. These elements make political cases easier to build, not just legal ones. Then there's discussion of the 25th Amendment. Even if it remains hypothetical, the logic is straightforward. If a president is consumed by legal jeopardy and the evidence appears overwhelming, political actors may debate capacity and responsibility. Whether that occurs is a political decision, but the fact that it is even discussed reflects the level of destabilization involved. The national security dimension may be the most serious aspect beyond politics. If Trump casually displayed military planning documents related to Iran to civilians, those materials likely contain sensitive information, not just plans, but intelligence, sources, methods, assessments, capabilities, vulnerabilities, and operational options. This is the type of information foreign intelligence services actively seek. Everyone present becomes a potential target for exploitation. Each disclosure increases risk. That is why this is not a trivial controversy. It is not merely embarrassing. It carries the potential for long-term damage. Even if nothing was copied or recorded, the act itself violates the responsibility presidents have to safeguard classified information. Precedent also matters. For decades, there has been an assumption that presidents face political consequences more often than criminal ones. A conviction of a former president for willful retention and obstruction related to classified materials would establish that criminal accountability applies at the highest level. In theory, that shapes future behavior. In practice, it creates immediate instability. Because the system is not designed for a sitting president confronting prosecution with evidence this direct. If trials move forward, the demands are substantial. Court appearances, preparation, constant media attention. Governing becomes more difficult, and pressure on allies increases. If prosecutors pursue obstruction-related charges against others, individuals will begin prioritizing their own exposure over loyalty. History shows that pattern clearly. Cooperating witnesses emerge when prison time becomes real. When loyalty carries severe personal cost, loyalty often erodes. That creates a chain reaction. One cooperator leads to another. More people face risk, and more choose to cooperate. That is how Trump's legal position becomes not just weak, but structurally constrained. You have his own voice on tape. You have alleged testimony from a key IT administrator regarding deletions. You have attorney admissions. You have potential privilege piercing exposing communications. You have judicial tools like contempt. You have revived indictments with multiple charges. This is why the sense of inevitability appears. Not because prosecutors always prevail. They do not. But because when evidence stacks up in this way, it becomes extremely difficult to construct a single alternative explanation that accounts for all of it. You can claim bias. You can claim politics. You can call it a witch hunt. But you cannot remove a recording. You cannot undo sworn testimony. You cannot ignore privilege rulings. Those are fixed facts within a legal framework. So when people ask what this means, it means the country is facing a situation it has rarely encountered.